Richard Decote, D-U-C-O-T-E. I'm an attorney, Louisiana attorney, office in New Orleans. My firm also has an office in Pittsburgh. I represent abused women and kids around the country. I've been doing that since really 1978 as an attorney for abused kids, and then since 1984 I've been representing moms and kids and fathers who are protective parents in these abuse, domestic violence custody cases around the country, and I've done that in over 40 states. Protective parents, particularly mothers, are still losing custody of their abused kids for several well-documented reasons that have been at play since I've been doing this. The first is the false and bogus and discredited pro-pedophile parental alienation syndrome theory, which is a cancer in the family court system. It was concocted by this lunatic Richard Gardner, who all of his writings are anti-Semitic, pro-pedophile. It really was a cover for his own demented agenda. But he did a real good job of selling it to lawyers and selling it to judges, and it went unchallenged by the legitimate people in the field for a number of years. And although it's really been publicized now in the professional community and in the court system that it's nonsense, we still see it in its purest form, Richard Gardner's parental alienation syndrome, being used by psychologists and the family bar and family court judges to take kids away from protective parents and give them to their abusers. Parental alienation syndrome is a theory that was concocted by this Richard Gardner, who a pro-pedophile, anti-Semitic, discredited psychiatrist. He sort of presented himself as on the faculty of Columbia Medical School. They distanced themselves from him. In fact, I was the last attorney to cross-examine him before he committed suicide. And he admitted there that he had not even spoken to the dean of Columbia Medical School for 15 years, and he had no hospital admitting privileges as a psychiatrist for over 25 years. He would just write this gibberish and publish it, and he was it was something that the defense bar, that attorneys who were representing child molesters and wife beaters and people who physically abuse their kids ate up, because the value of parental alienation syndrome, if you're a defense attorney, is that it's a self-fulfilling defense, because all it is taking the evidence of actual abuse and calling it non-abuse. So the more evidence of abuse there is, if you're a follower of Richard Gardner, you just redefine that as evidence that the mother made it all up. So that's why it's so effective. It's just like if you had if the issue was bank robbery, and you had some lunatic psychiatrist who would pronounce that he discovered the false bank robbery syndrome. And the evidence of false bank robbery syndrome was that the teller identified that person as sticking the gun in her face. And the person who the teller identified was caught on the video camera at the teller window. And then that person is caught outside the bank with the cash and the die that blew up and coded the money. That under the false bank robbery syndrome, that would mean that the teller made it all up if you have those elements. And that's what we see in the parental alienation syndrome, because the elements of parental alienation syndrome are, in essence, elements of real abuse. So sexual abuse of kids is the only crime that comes with a built-in defense. And that's the mother made it up, and you see that in every case. There was a case recently in Louisiana, just within the last month, where a man was convicted by a criminal court jury of molesting his daughter, and this man kept 12 detailed notebooks in his own handwriting documenting his raping his own daughter. And then he confessed to the police on 3 different occasions that he had done it. His defense at the trial was that his wife made it all up, that she had forced him to make the notebooks, and that once he had made these notebooks detailing all this, then he figured he might as well confess to the police because he had already written in the notebooks. So he actually got on the witness stand and testified that the wife had made it all up so she could get sole custody. Now, in a criminal court where the burden of proof is beyond a reasonable doubt, and you had a jury focused on facts, that was summarily rejected, and he's going to go to prison for the rest of his life. However, had that been in a family court with a family court judge, quite likely that defense would have been bought, and that person may well have gotten custody, and the wife would have been chastised and penalized and would have been put on supervised visitation for doing something that's so horrible as forcing her husband to keep 12 notebooks describing this stuff. That's how bad it is. It is the worst tragedy that I have seen on a systematic basis in our American court system, because it's a false trap. We tell parents, if your child's being abused, protect them at all costs. If you don't, the child welfare officials will come and take the child away for neglect. If you're living with the man who's beating you and molesting your kids, don't stay. You've got to be strong. Well, then when moms listen to that advice, and they have all the documentation there is, even in some cases physical findings, and you have these cases where child pornography, which alone could send somebody to prison, is found on the father's computer, and the descriptions of the child pornography match what the child describes that the father does, and all this. And the family court judge says that's evidence that the mother made it up or that the father should get custody. It's a very horrible, horrible trick that's played on parents, and how moms in this situation, and moms are most often the victims, certainly their fathers who are protective parents who go through the same thing, how they just don't simply lose their mind, because the vast majority of the moms in these situations have never been in any trouble whatsoever. They've just been mothers, they're professionals, they have done what we expect them to do in society. Do everything, have a job, go to school, take care of your kids, protect your kids, go to the PTA, be involved in the classroom, do everything. And then the very first time that they turn to the legal system and say, well, I've heard the PSAs, and I know I'm supposed to protect my kids, and I know I'm not supposed to stay in an abusive situation, and they go to the legal system that's been telling them that that's what you're supposed to do, and they get crucified in the process. It's really despicable. I've been doing this almost full time since 1984, and I see it play out over and over and over and over. And what we've learned is if you can get involved early enough and you make the courts work like courts are supposed to work, and you make the lawyers work like lawyers are supposed to work, the majority of the cases you can make sure that the right thing is done. But when so many things have already happened that are wrong, and you try to undo these bad decisions, it can be done, but it's often very difficult. The other problem, besides parental alienation syndrome, and there are two other things that really contribute to this problem. The first is this entity called the guardian ad litem. The guardian ad litem is typically an attorney who is supposed to represent the child's interest in the court. Well, that's, again, a very, very deceptive, dangerous, again, a trick that's played on kids and women in the family court system. Because, and I often use this example, if we go back to the bank robbery, if the issue in a criminal trial was whether or not somebody committed the bank robbery, the judge or the jury would hear the evidence. They'd hear from the teller, they would look at the videos, et cetera, hear from the witnesses. They would not appoint an attorney to kind of not do anything, some attorney that the judge knows who needs some extra money, and have that attorney come in and say, well, Judge, I've talked to some people, and I've done this, I've done that, and this is what I think. Forget all the evidence. Just listen to me, and I think that the man did not rob the bank. Okay, well, that's the end of the story because this is all we want to hear. Well, that's the role that the guardian ad litem serves in the family court. Now, for the most part, they're untrained. They don't know anything about abuse. They don't do anything. They don't talk to the kids. They don't interview the kids about the abuse. And it's a very tight cabal. It's a clique in family court between the guardian ad litem, the judge. Typically, the third part of the problem being the custody evaluator, the psychologist. And for 23 years now, I've read reports from psychologists and psychiatrists who get involved in these cases, who are appointed by the judge, who say, I decide that, or I believe there's no abuse here and the mother made it up. And I sit and ask them the same questions over and over. Have you ever had any training in abuse or domestic violence? No. Can you name one book that's ever been written about domestic violence or sexual abuse? No. Have you ever treated a child who's been sexually abused? No. Have you ever gone to a workshop? And they don't know anything, but yet the system has deferred to them, and they're in a very powerful position, and if you challenge them or if you file complaints against them, everybody gets upset because for the most part, and it's very, very sad for me as an attorney to say this, but this has been my experience. The family court likes everybody to get along and work things out and cooperate and sing kumbaya. That's what the family court wants. And that's great in the vast majority of cases where there's no abuse, no domestic violence, no substance abuse, nothing that really places any of the kids or any of the spouses in danger. But when people are at risk of abuse or neglect or craziness, then the court has to work like a court. It has to function as a fact finder, and it can only do that based on evidence and proper procedures, and the lawyers have to act like lawyers. But the family court doesn't want to do that. They want to have a one-size-fits-all. And if you come into family court and you say, look, my case is different. It's a case that involves bad facts, that this person is up to bad things, and they are putting our child at risk, then the family court automatically labels you the troublemaker, and it's a little cabal, it's a little clique, and it's a terrible, terrible situation, and the court is not interested in the truth. The court is not interested in facts. The court is interested in these psychological theories, in protecting people's reputation, protecting psychologists' practices, and to watch this and to see the suffering, the human suffering, the suffering of the kids and the parents who are at the mercy of the family court system that pretends to be something that it isn't in a lot of instances. And of course they're good, very good judges, and they're good lawyers, and they're good custody evaluators. But the problems we see are the cases where things are not happening correctly. And it's the same problems over and over and over. The parental alienation syndrome, the bad custody evaluators, the bad guardian ad litem, and a judge who isn't going to make decisions on the basis of evidence. It's not the law. Every judge in this country has every law that he or she needs to do the right thing in these cases and to do whatever needs to be done to protect abuse victims. The only laws that are needed are laws to prohibit these guardians ad litem and these custody evaluators from doing what they're doing, and to force the judges to act in accordance with certain principles. For example, this thing with the guardians ad litem, the American Bar Association in 2003 issued standards of practice that say it is unethical for an attorney to act as guardian ad litem because it's not an attorney's role. An attorney is supposed to be an attorney. You get up, you ask questions, you call witnesses, you argue the law. You don't get up there and say, listen to me, I'm the one who knows what should be done here. But that practice that is inappropriate is still utilized around the country. So there's so many obvious fixes that need to be imposed, and it's a very, very frustrating problem.